Good morning. So my topic for presentation is the doctrine of notional extension. So this comes under the labor law. So as we all know, an employee who suffers any kind of personal injury or any kind of accident in the course and arising out of his employment, then he is able to claim compensation, entitled to claim compensation from the employer under the Workman Compensation Act of 1923 as well as the Employee State Insurance Act of 1948, and this will be decided according to the doctrine of notional extension, which has been developed by the courts through various judgments. So basically, in order to claim compensation, in order for a workman to claim compensation, that particular injury or accident should have arisen out of the employment. If it is not out of the employment, then he cannot claim any compensation. However, other than this, in the course and arising out of employment, there is one other state wherein that employee can claim compensation from the employer for any accident or personal injury suffered. So that is the area of doctrine of notional extension. The doctrine of notional extension states that apart from in the course and arising out of employment, while case of traveling to and from work also, if certain conditions are satisfied, then the employee is entitled to take compensation from the employer. So this compensation is basically given under the section 3 clause 1 of the Workman Compensation Act of 1923, and it says certain circumstances which has to be fulfilled in order to claim compensation. So firstly, there must be some kind of personal injury or accident which must have been caused to the employee, and such an injury must have been caused by an accident which is in the course of or arising out of the course of his employment, and in such case, if it is resulted in the death of the employee or his total or partial disablement for a period exceeding 3 days, then the employee is entitled to claim compensation under the Workman Compensation Act. So in the course and arising out of. So what is this in the course and arising out of employment? So it is nothing but this in the course and arising out of basically indicates the place and circumstances under which the accident causing the injury took place. So or the time at which it occurred. For example, if your employee is working in a factory, then if an accident occurs to him while he was working in a specified time, maybe in his shift or at the particular factory itself where he was working during his employment, so that is in the course and arising out of employment. So basically, a casual connection and a basic connection must be established between the injury which has occurred as well as the course of employment. Only in such a case the employer can claim compensation. In such cases, the burden of proof to prove that such a connection establish such connection lies upon the claimant. The employee should actually be able to prove that the accident occurred in the course of his employment. So employee must show that at the time of the injury he was in the employer's business or in his workplace, and he was doing his particular business and was not doing anything for his own benefit. So this doctrine of notional extension states that, as we all know, a particular man's employment will begin only when after he reaches the place of employment. So, but in certain cases, even while traveling to and traveling from the place of employment, such compensation such men can incur an accident and he can claim compensation for it. So traveling to and from the employer's establishment is prima facie not in the course of employment, but in certain instances or cases there may be a reasonable extension of time and place, and then the employee will be regarded as in the course of employment, and he has not, even though he has not reached or left his place of employment. So the doctrine of notional extension was first clearly established in the case of St. Helens Colliery Co. vs. Helfton. In this case, the employees were working in a colliery were injured while traveling in a special coiler's train, wherein the train was arranged for the transport of the employee of the colliery alone. However, the court held that this was not in the course of employment and doctrine of notional extension will not apply in this case. The reason is that even though they had a special train for the employees of the colliery, there was no obligation for the employees to travel only by that train. There were other means of transport also, and the employees contract also did not have any condition that they should travel in this train. And therefore, since there was no obligation to travel by that train and there was no implied or expressed term in the contract of service that they have to travel that particular transport, and therefore the employer was held not liable. And unless, therefore, the main point to note that unless they are bound to travel that particular transport, they will not be held liable. So there is another case wherein Varadarajulu versus Boyan. In this case, the employer was a contractor for formation of a road, and the deceased employee, the accident for whom the employee occurred, so he was a coolie mystery again under him. So the employee suffered injury by capsizing of the lorry which belonged to the contractor and was driven by his driver when the lorry was conveying the employees to the place of business. So in this case, since the area of location of work was on top of a quarry, there was no other means of transport to reach that particular place, and therefore when it was the court held that when it is the only means of transport, and then it will be held to be in the course of employment, and the employee's dependents, the deceased dependents, were given compensation here. So in case of when does it not applicable? So where accident occurs in a public place and the risk faced by the employee is not due to his employment, but on when he is as in that particular place as a part of a public, then the employer will not be held liable to pay compensation. So in case of J.F. Pereira versus Eastern Watch & Co. Limited, the salesman working in the company, he went out and he was found unconscious on the third floor of the building, and while transporting him to the hospital, he died on the way. So the court held that workman can go out during work. It is not necessary that he must exactly be found inside the work premises alone. So unless it could be proved that he went out for personal reasons, then the employer will be held liable in this case. And the other case such as Saurashtra Salt Manufacturing Co. versus Varalu Raja. So in this case, when the workman court held that when the workman is on a public road or a public place or public transport, then he is as a member of public and he is not in the course of his employment, and therefore in such cases the employer will be not held to be liable. So concluding, the main conditions in order to claim compensation even while traveling is that there must be an obligation to provide transport and a reciprocal obligation on the employee to avail that particular transport alone. And where it is only means of transport to workplace, then it will be taken as an implied condition and the employer will be held liable. Whereas in case of a public place, the employer can be held liable only if it can be shown that the employment made compulsory for him to be there. Thank you.